is now starting. All attendees are in listen-only mode.
Good afternoon. I'm Amy Quackenboss, the Deputy Executive Director of the American Bankruptcy Institute. I am pleased to welcome you today to the next webinar in our ABI-Live series. Today's webinar, which is hosted by ABI's Commercial Fraud Committee, is entitled All About Bankruptcy Fraud with a Dose of Reality TV. Today's webinar will focus on the criminal bankruptcy fraud provisions of Title 28. The presentation will use examples from well-known bankruptcy fraud cases to illustrate how these laws play out in practice. Before I introduce you to the panel of speakers today, I'd like to address a couple of housekeeping matters. If you need CLE, please make sure you're recording the CLE codes that will appear on your screen throughout the program. Also, during the webinar, if you have questions for the panelists, please type them in the GoToWebinar conversation box on the right of your screen. These questions will be sent directly to our panelists. I am now pleased to introduce today's panel. Our first speaker is Eric Madden, who is a partner at Reed, Collins & Desai in Dallas, Texas. Eric focuses his practice on complex bankruptcy and business litigation, representing trustees, committees, and investors, and he frequently handles bankruptcy-related litigation involving parallel criminal or regulatory proceedings. Eric is also currently the co-chair of ABI's Commercial Fraud Committee. Our next panelist is Matthias Kleinsasser, who is a partner at Forsey & Prostock in Fort Worth, Texas. Matthias represents debtors, creditors, and trustees in business bankruptcy cases and has substantial experience in bankruptcy-related litigation. We are also pleased to be joined by Erin Schmidt. Erin is a trial attorney with the United States Trustee's Office in Dallas, where she is the appellate coordinator for Region 6. Erin is also a member of the Honorable John C. Ford American Inn of Court. Each of our panelists has extensive experience with cases involving bankruptcy fraud, and we are pleased to have them with us today. So Eric, I'll turn the program over to you to begin.
Thank you, Amy, and welcome to today's webinar about bankruptcy fraud. We have what we hope you'll find to be an informative and entertaining webinar all about bankruptcy fraud and the reality TV stars and others who've been caught up in that. Let's start off by defining the topic. Matthias, why don't you tell us what is bankruptcy fraud?
Yeah, okay. Thank you, Eric. So strictly speaking, we kind of throw the term bankruptcy fraud around frequently, and if you look at bankruptcy fraud convictions, you'll frequently see people that were convicted under multiple statutes of Chapter 9 of Title 18. You know, maybe Section 152, Section 157, et cetera. And these all kind of relate to bankruptcy crimes, might be a better term for it. But strictly speaking, bankruptcy fraud is covered by 18 U.S.C. Section 157. And that section prohibits, as part of a scheme or artifice to defraud, the filing of a bankruptcy petition, filing of a document in a bankruptcy proceeding, the making of a false or fraudulent representation in relation to a bankruptcy proceeding, and the making of a false or fraudulent representation in relation to a bankruptcy that is not, in fact, pending. And I think that the fundamental thing to notice about this particular section is essentially this. If you are trying to effectuate a scheme or artifice to defraud through a bankruptcy and you take some action, whether it's filing a bankruptcy to effectuate that scheme or artifice to defraud, or you even take the position that you did file bankruptcy when you in fact did not, that's going to be covered by this section. So I think that's the main takeaway here.
Does this statute apply only to debtors, or could it apply to creditors and other participants in the bankruptcy case?
No, it's pretty broad, as with most criminal statutes. So, really anyone who takes any action covered by the broad language of the statute is going to be covered here. So, if for some reason a creditor were trying to perpetuate a scheme to defraud and filed some kind of a document in a bankruptcy proceeding that was already pending by a debtor who was not involved in the fraud, that would plainly be covered by the statute. So, anyone who takes any kind of action covered by this in a bankruptcy proceeding is going to fall within the scope of the statute.
Even counsel?
Absolutely.
Okay. So let's go to the next slide and let's talk about some examples, specific examples of how the statute might be violated by either a debtor, a creditor, or his or her counsel.
Sure. So, for example, if you are trying to perpetuate some kind of a fraudulent scheme with respect to issuing securities through a bankruptcy proceeding, and you file a disclosure statement containing false information, I mean, and that's basically akin to, let's say you make some kind of a disclosure with the SEC outside of bankruptcy to perpetuate a fraud. That's going to be covered by other criminal statutes, right? So in the particular case I'm talking about with the disclosure statement, that would be covered by Section 157. Or, for example, telling a creditor you filed bankruptcy when, in fact, you did not to buy time to perpetuate a fraudulent scheme. You are perpetuating a fraudulent scheme there by representing that a bankruptcy is pending, which is not, which, again, probably not something that gets charged very frequently here. It's a lot more likely that you see people that actually, filed bankruptcy to commit fraud or hid assets or something like that. But if you do that, that is covered by this section. And, so to take a look at this photo here, there's obviously some irregularities in the documents this cat is looking at, and if these irregularities are in a disclosure statement that's filed in the case, then that's going to be covered by Section 157.
Got it. So, by the way, I think it's really sweet that you included a photo of your cat here, but I think it's interesting here in this last example that you've given that a person can commit bankruptcy fraud even when a bankruptcy case isn't actually pending. Is that right?
Yeah, absolutely. And a lot of this is, I don't want to say it's theoretical because it certainly isn't. Like I said, it's a lot more frequent, though. You'll see people charged with fraud in relation to a bankruptcy that is, in fact, pending. But if you tell someone that you're in bankruptcy to perpetuate some kind of a fraud, maybe, I suppose, for example, you want to stop a collection action and you make that representation so that you can fraudulently swirl away your property, that could potentially be covered by Section 157. And just to clarify regarding the cat, Mr. Whiskers needs to be involved in every presentation I make, as anyone who does these kind of things can tell me. So that's why we had to include him here, even if he can't be here in person.
All right. Well, what if somebody commits one of these acts, but no one believes, like, for example, a false or fraudulent statement in the disclosure statement? Let's say no one believes it, or no actual harm has occurred. Is that still bankruptcy fraud?
Yeah, it is. Reason being that technically harm is not a requirement to be charged under the statute. So, it's different than, say, a civil lawsuit where frequently your cause of action almost always is going to require some kind of damages. Just because if you commit this type of action that violates the statute, and even if, they can't actually prove that somebody relied on it and was harmed as a result, then you can still be charged. So it's really incentive to get everyone to comply with the rules, I would say, from a policy perspective, rather than, some kind of a restitution statute or something like that.
Okay. So that's Section 157. Let's go to the next slide. And Erin, are there other statutes relevant to bankruptcy fraud?
Absolutely. There's 18 U.S.C. Section 152, which prohibits, among other things, the fraudulent concealment of property of the estate. So, for example, if a Chapter 11 debtor brings in extra income but doesn't report that income, that would be fraudulent concealment. False statements under penalty of perjury. Their debtors are required to sign schedules and a statement of financial affairs. They testify under oath at a 341 meeting. Any false statements made in those type of contexts would be prohibited under Section 152. Fraudulently receiving property from a debtor. And so, for example, if a debtor transfers property to a family member to hold on to, that could be a crime under this section. And then offering or receiving compensation for a fraudulent action in a bankruptcy case would also be covered by this.
Okay. So this statute seems a little different from Section 157. We saw how 157 could apply even if a bankruptcy case hadn't actually been filed at all. But Section 152, on the other hand, seems to require a case under Title 11. Is that right?
I would certainly, yes. Yes, but these are crimes committed in the context of a bankruptcy.
Okay. And this statute requires that the acts be committed knowingly and fraudulently. What does that mean?
There has to be some sort of mens rea. There has to be some type of intent. Mm-hmm. And so I think you have to show that the party committing the violating 152 intended to conceal assets or intended to commit perjury.
Okay. So, Matthias, does knowingly mean that the person knew he or she was doing something illegal?
So I think what you're asking essentially is this a specific intent, like, kind of issue? And the answer is no. I mean, knowingly really means that the person intended to take the action that causes the crime here. You don't have to actually intend to specifically violate Section 152. And frankly, probably plenty of people that are convicted under bankruptcy fraud statutes have never even heard of this section. So knowingly here is the more common version in the law, which really just means you intended to take the action that was taken.
Got it. Okay.
I would agree with Matthias on that.
All right, let's go to the next slide. And Aaron, could you walk us through some examples of how Section 152 might be violated?
Absolutely. So, for example, if you're hiding cash under your mattress in your house and you don't disclose it on Schedule AB, certainly that would be concealment of assets. If you're a creditor and you file a proof of claim against the estate for money that you know is not owed, that also would be a type of fraud. An attorney or bankruptcy petition preparer accepting money from a client to falsify bankruptcy documents, that would be a crime under this section. And trying to bribe a bankruptcy trustee would certainly fall within this section.
Got it. Okay. Let's go to the next slide. And Matthias, why don't you tell us about Section 153 and what that entails?
Sure. So the gist of Section 153 this is frequently referred to as the embezzlement section, although technically it covers a little more than that. And what it prohibits generally is the knowing and fraudulent appropriation, embezzlement, or transfer of property of the estate, the destruction of documents belonging to the estate, and by a trustee, custodian, marshal, attorney, or other officer of the court. So to give you an example, if you're an attorney as an officer of the court and your client has some documents that would subject him to liability in a bankruptcy proceeding, and you just decide to, put those in the incinerator, you violated Section 153. The second prong of it there that's on the slide. Another thing would be, for example, if you're as an attorney and an officer of the court, you have custody of property of the estate, maybe by means of, some kind of a retainer from your client, and you embezzle it and, put it in, say, a house in the Cayman Islands, that would probably violate Section 153.
Okay. Could this statute apply to a lower level employee? For example, if your legal assistant were to embezzle property out of the retainer account or to otherwise transfer estate assets in some way, could the statute apply there?
Yeah, to the extent that this is someone who's acting on behalf of you as an officer of the court. Typically with the agency laws will apply in these statutes. In the particular example you've given, it would.
Okay. What about to a post-confirmation representative of the estate, like maybe a liquidating trustee? Would it apply there, do you think?
I think it would. I'm not sure that I've seen a specific example of that occurring, but I think that would definitely fall in the statute.
Okay. So let's go to the next slide, and let's talk about some examples of violations of Section 153.
Sure. So, for example, let's say the debtor's attorney steals cash from the DIP account. That's an example I already gave. I mean, that could classify as embezzlement. Typically with embezzlement, what we think of is that you have proper custody of something, but then you put it to some kind of a misappropriation or improper use. So, you know, that would fall within this. Another example might be, you know, someone who destroys property of the estate. I mean, the destruction of property of the estate falls within the statute. So those are all examples that would be covered there.
And does Section 153 involve the same sort of knowingly and fraudulent sort of mens rea type requirement that we talked about earlier?
You know, actually, Aaron, could you actually weigh in on this? I think you'd have a little more experience with that requirement than I would. In this case.
Sure. I mean, obviously, for most crimes, there is a mens rea requirement, but as Matthias indicated earlier, it's not that you even have to know about the specific statute, but if you are an officer, a responsible party for state assets, and you deliberately commit any of these actions, then yes, that would be knowingly.
Okay.
Violating the statute.
All right. So we've talked about 152, 153, 157. Are there other relevant statutes? What about Section 155 on the next slide? And I guess I'll take that back to Matthias.
Sure. Yeah. No, I was waiting for the slide to come up. So 155 generally prohibits debtor, creditor, trustee, or attorney from knowing and fraudulently entering into an agreement for the purpose of fixing fees or other compensation from the estate. And so this is one that, in what I've done for my own research, I have not seen charged as frequently as Sections 152 and 157. But the way this would work, for example, is that, you know, as a debtor's attorney, for example, if somehow you enter into an agreement with the trustee to get some kind of fraudulent fee out of the estate, you know, without, say, court approval, through some kind of scheme to effectuate a fraud, that's going to be covered here. So, again, not something you tend to see quite as frequently as, say, destruction of property or hiding assets or that kind of thing, but something that you can see how that could come about fairly easily.
Okay. This statute, by the way, applies not just to bankruptcy cases, but also receivership cases. Is that right?
Yeah, I think that's right. So, you know, for example, if you were in a federal receivership, the same kind of this statute would be covered in that. You know, let's say, for example, you take this kind of action in a receivership brought, you know, in relation to a Securities and Exchange Commission action. Mm-hmm. That would also fall within this statute.
Okay, so we've talked about some of the primary statutes dealing with bankruptcy fraud. I think it's important to note that there are others found in Chapter 9 of Title 18, but let's shift gears and talk about some of the penalties for violating these statutes. And that's on the next slide here. Who wants to take the lead here?
I'm happy to. So some of the possible penalties for violating these crimes include, obviously, fines, having to pay money, fines, getting your name in the Federal Reporter, losing your right to vote, losing your right to own firearms, which can be especially harsh if the person who's been convicted enjoys hunting, and then up to 5 years free room and board, courtesy of the federal government. So you can go to prison for committing bankruptcy crimes.
Okay, and as reflected on the next slide, there's some great networking opportunities you'll find in prison, right?
Absolutely. You get to meet, I think you get to meet some interesting people sometimes in prison.
Oh, absolutely, from a diverse array of backgrounds. And if nothing else, it may provide different career opportunities when you get out after serving your 5 years or 1 year in the case of a Section 155 offense. So there is that upside, I suppose.
Okay. going to the next slide then, in addition to just the bankruptcy fraud violations that we've talked about, these kinds of acts can also expose a person to other criminal liability under other statutes. Is that right?
It is, and I think that's really important to note here, because not to make light of the, Chapter 9 punishments of 5 years in prison for most of those offenses, but the reality is frequently when people commit some kind of bankruptcy fraud or bankruptcy crime, they tend to have violated other statutes: wire fraud, mail fraud, bank fraud, not infrequent. And the key thing to note there is that those statutes have far more draconian penalties for the most part, than say a bankruptcy fraud statute does. Some of them may have up to 30 years in prison, for example. And typically, and we'll get to some of this when we deal with the celebrities who have engaged in naughty behavior that we're about to discuss in the later slides. But a lot of what they were convicted under was not simply bankruptcy crimes per se, like Section 157 or Section 152, but also that they violated other criminal statutes that apply in bankruptcy proceedings to the extent someone takes those criminal actions, as well as across the board and anything else. And so I think that's the important thing to note here with respect to, any client that you may believe is engaged in naughty behavior and who potentially may not be deferred by the risk of 5 years in prison, is that there are much more draconian punishments that can land you free room and board for a lot longer. Aaron, do you have anything to add?
A few things. Just to note that we've seen sometimes where when a debtor who has committed bankruptcy, we've seen where debtors may have committed other types of fraud or criminal activities prior to filing for bankruptcy. There's the old saying that bankruptcy is the last refuge of the scoundrel. The other thing, too, is it's very easy to be implicated in mail fraud or wire fraud if, for example, a party has falsified a proof of claim and mailed it, or sending a falsified bankruptcy document via fax. And so there's ways that other statutes can also be implicated with bankruptcy crimes. Another common issue is misuse or using false or other people's Social Security numbers. So there's a variety of ways that a party may be charged with several counts.
Okay. Yeah, and I'll add one more thing real quick, Eric, before you jump in. Sure. Most likely the bulk of people listening to this webinar are attorneys, and if you look at the last bullet on the slide there, the aiding and abetting 18 U.S.C. Section 2, that's most likely the way that an attorney might get involved or might be charged with, it's a likely way with a bankruptcy-related crime. And you can see how that would work. For example, if an attorney tells the client to do something fraudulent, to destroy property, to hide records in a bankruptcy proceeding, to commit perjury would fall under Section 1622. So I think it's important to note, since probably the bulk of the people listening to this are attorneys, that those two statutes absolutely would apply here. They frequently are implicated in bankruptcy-related crimes, and it's most likely the way that an attorney is going to get caught and in trouble.
Right, and turning to the next slide, we have some examples of that, and I think the first example, Matthias, is a good example of how an attorney could potentially be caught up in some of these other statutes. Why don't you walk us through these?
Sure. So if my client tells me that, look, I've got $1 million and I want you to just say that I only have $150,000, or in this case, if you suggest your client made that misrepresentation on his bankruptcy schedules, which, as most people I think know who are involved in bankruptcy, are signed under penalty of perjury, then what you are encouraging, if you do that as an attorney, you are encouraging your client to violate Section 1622, and your client has also violated Section 152, concealment of assets with respect to a bankruptcy proceeding. Reality is there's probably a whole lot of other stuff that's violated here, potentially Section 157, the filing of a false document, to perpetuate some kind of scheme or artifice to defraud. But at a minimum, we've got 1622 and 152 here, and the attorney's going to fall into the former section.
Okay.
And or to give you another example, I guess we'll go to the second example here. If someone were to take out a personal loan from a bank, knowing it'll never be paid back, and that little fact is in there just to clarify that the fraudulent intent is there when the loan is taken out. It's not a situation where you've got someone who thought he'd pay something back and then was not able to do it fundamentally. And then, so if that person spends the money and then files for bankruptcy, that's probably going to violate Section 1344, bank fraud, Section 157, potentially bankruptcy fraud, and probably Section 152 in there somewhere. I haven't actually gone through the analysis, but it's likely implicated. So you can see how these things tie in very, very well with bankruptcy crimes, the other federal statutes that more generally regulate criminal behavior outside of bankruptcy too.
Okay, let's talk about the fun stuff. Let's go to the next slide, and then let's talk about some of the famous bankruptcy fraudsters. And let's turn it over to our reality TV expert, Erin. And Erin, who do we have here?
We have here Joe Giudice. I'm not sure if it's on the show. I think they pronounce their name Giudice, but I think I've also heard it pronounced Giudice. But this is Joe, who is Teresa's husband from the Real Housewives of New Jersey. And so the Giudices, they're featured on obviously the Real Housewives of New Jersey, and pretty much what they do is they look fabulous, they wear elaborate and expensive clothing, big hair, and they spend time just fighting with friends and family. Joe and Teresa, they also had various business ventures. Teresa is also an author. She's written a number of cookbooks, and she's also published a couple of memoirs relating her experiences.
Okay, well, let's talk about what did they do. That's on the next slide.
Absolutely. So Joe and Teresa filed for bankruptcy in 2009, and the case was subsequently dismissed, but in their filing, they failed to disclose in their schedules income that they received from the show Real Housewives. And so, for example, they had signed this agreement stating that they would get a talent fee of $110,000, but they didn't disclose that. They also didn't disclose income from various rental properties. And also, too, Teresa had some outside businesses. She had a company called TG Fabulicious, and she didn't disclose a website for that business or its bank accounts and whatnot. The couple also didn't disclose a clothing line company that Joe owned, and I think another entity called Turbo Fuel. So they just didn't disclose all of their assets on their schedules.
Sounds like multiple violations. So what were they charged with specifically?
Well, they were charged with mail and wire fraud. They were charged with bank fraud. There were many, many, many counts. I think there was a total of 39 counts of conspiracy to commit mail and wire fraud, bank fraud, false statements on loan applications, and then obviously the aforementioned bankruptcy fraud.
So this is a good example of how acts that constitute bankruptcy fraud constitute violations of multiple other criminal statutes.
Yes. Oh, absolutely. No, absolutely.
So what was the sentence?
Well, Teresa was sentenced to 11 months, and her husband, Joe, was sentenced to, oh goodness, I think it was 41 months. They served the sentences separately because they have 4 children, and so to prevent hardship on the children, Teresa served her time first, and now her husband Joe is currently serving his sentence. And the other thing, too, is that Joe is actually a citizen of Italy, and so there's actually the potential he may be deported after he serves his term.
Okay. It seems to me like maybe their bankruptcy counsel may have missed some obvious issues, like failing to disclose income from a famous TV show. That seems pretty obvious. Maybe their counsel didn't act knowingly as required under some of these bankruptcy fraud statutes, but perhaps counsel failed to conduct a reasonable investigation or failed to act with reasonable diligence as required under ethical rules. Was their counsel ever charged with anything, either criminal or ethical violations?
No, well, I do know that her counsel, gentleman named James Creedle, she has sued for $5 million, blaming her counsel for financial omissions and errors. And she's alleging that her counsel didn't adequately consult with her before the filing of the joint petition. I would note, however, that debtors have an independent duty to read their schedules and their statement of financial affairs before signing them. So I certainly her counsel may have avoided some of these legal issues by better going over these matters with his clients before they signed and filed their bankruptcy documents. But debtors, I still bear that burden of reviewing those documents before signing.
Okay, so it sounds like Teresa sued her former counsel for malpractice, and
yes.
At the end of the presentation, we'll talk about some of the steps attorneys can take to avoid getting caught up in either allegations of malpractice or aiding and abetting bankruptcy fraud. So let's
no, absolutely.
Let's shift gears and let's talk about.
Actually, Eric, let me just jump in real quick before we get to Lenny,
Sure.
with just a couple of things. I think that what we're really underscoring here, well, we should be underscoring, and we will at the end more. But frankly, as an attorney, since again many of the people on this webinar are going to be attorneys, the most likely way you're likely to get in trouble here if your client commits bankruptcy fraud, frankly, is not just with being charged criminally yourself. Frankly, that's probably less likely as long as you do your diligence there. But if you get a little sloppy on it, I mean, there's a pretty good chance that the client's going to make some allegation. I mean, again, we're talking about fraudsters here, right, against you, and say that somehow you committed malpractice or some other type of tort. And, you know, as long as you haven't actually committed fraud, the odds of you actually getting charged and convicted for fraud are probably pretty low. But, you know, the odds of a disciplinary complaint being filed against you or a malpractice allegation, a lot higher. And obviously, as we all know, that's not something anyone wants to deal with. To the extent that fraud was committed, it may even be the type of thing that a malpractice carrier would try to opt out of based on the policy. So, you know, we can talk more about that issue later, but I think this is a really good example of the risk that attorneys face, not just with respect to the criminal statutes, but to sort of secondary tort liability that can result when your client gets charged and convicted and you don't. So, you know, aside from that, the only other thing I would add here is I do question whether it would be a punishment to be deported to Italy. However, we'll see if that happens. It may be actually better to keep him with his family given their tempestuous relationship on the show, at least, if that is accurate here. But, you know, that remains to be seen when he gets out.
I think you just admitted to being a fan of that TV show.
I'm not saying I've ever watched it. I'm not going to deny it.
All right, well, let's say, so we were just talking about Teresa's malpractice claim against her attorney, and maybe we don't know the outcome of that case, but would the recovery from that action belong to the bankruptcy estate? In her case, I'm not sure it would, because it sounds like the case was dismissed, so the estate no longer exists. But let's say that the case were still open, the bankruptcy case itself, and a debtor wanted to bring a claim, or the estate, the trustee for the estate wanted to bring a claim for malpractice against debtor's counsel. would that recovery belong to the estate?
Yeah, I think in certain circumstances, like what you're describing there, it very well could. I mean, if the harm occurred pre-petition, then it's going to be property of the estate, and very likely a trustee may want to bring that type of action, which frankly is kind of a great point, because it really underscores how even if your client isn't necessarily mad at you, the trustee may see that as a source of recovery for creditors or something like that. So, yet again, another risk and another reason to do your diligence. Aaron, do you have anything? What do you think of my analysis?
No, I would agree. I mean, it could potentially be seen as estate assets, and certainly a trustee may want to get involved by possibly, if the case had been closed, reopening the case to administer those proceeds as assets. And so it's not just simply potentially it's not just the debtor, the client who's been harmed, but also the estate and creditors.
Right. Okay. Well, let's talk about sports. We probably have some sports fans on the line, and here we have Lenny Dykstra. Matthias, let's talk about him.
Yeah. So many people remember Lenny. When I was a kid, he was an all-star outfielder. Played 12 years for the Mets and the Phillies. And he won I believe he was on the Mets 1986 World Series team that won the World Series. So this was a guy who was very prominent and a real controversial guy. For example, one year, I believe it was 1993, but I'm not positive about that, he had led the league in walks, and he subsequently contended that he had actually bribed umpires to the tune of $500,000. I'm sorry, he had paid $500,000 to get dirt collected on the umpires so he could blackmail them into, I guess, contracting the strike zone with respect to him specifically, which to me seems like unless you really just want to lead the nation in walks, I'm not sure if that would be worth it in terms of money, leaving aside the morality of the whole thing. But that's what he contended he did. Believe it or don't believe it. Anyway, so Mr. Dykstra, he has a fairly successful Major League Baseball career, and he subsequently founded several companies, including one called Nails Investments, which he used to impart information regarding his investment ideas. And I think it kind of goes without saying that everyone should take financial advice from a guy who's nicknamed Nails, right? I mean, my financial advisor, I'm very disappointed, does not have a similar nickname that inspires fear, in my creditors or whatever. But anyway, so that's what he did. Subsequently, things did not go well. He made a bunch of different investments, and he had numerous companies. One of which was a company he formed called the Players Club, which was intended to, I believe, target pro athletes. That was their market base. It was going to have private jets and a magazine, etc. And I'll just point out that pro athletes are a fairly small share of the market, so I would assume you would have had to have had a pretty high retention rate to actually make that successful. But anyway, many of his investments went bad, and the most notable one was he attempted to flip Wayne Gretzky's former mansion, which Lenny Dykstra had purchased for, I believe, about $17.5 million. Well, ultimately he filed for Chapter 11 in 2009, and he was apparently soon within a month living out of his car and in hotel lobbies, which actually, depending on the hotel in Los Angeles, that may not be too bad. But anyway, he owned multiple pieces of real property which were damaged and destroyed. And among other things, he concealed a substantial amount of memorabilia, baseball gloves, certain things that were taken from the Gretzky mansion. And he sold or destroyed at least $200,000 in property of the estate. And actually, my favorite thing he probably did was he was alleged to have taken a numerous amount of furnishings from the Gretzky mansion and actually taken them to a consignment store in the back of a truck or cash, which he allegedly then pocketed. So, ultimately, he was charged and convicted, and he pled guilty to concealment of assets, bankruptcy fraud, money laundering, embezzlement, and false declarations before a grand jury or court. He also got caught up in a grand theft auto scheme, and he's had numerous other run-ins with the law, which, I mean, this being a PG program, I'm going to leave most of those out of here. You can look them up online and see what the allegations are. They go back to, frankly, his playing days. They're pretty, some of them are pretty gruesome. But anyway, ultimately, he served about 6.5 months in the pen, and he was ordered to pay $200,000 in restitution and perform 500 hours of community service, which, frankly, doesn't seem actually that bad given what he actually pled guilty to and was charged with. But that's what ultimately happened to Lenny. It did, for the most part, derail his investment career. You know, for example, prior to this all going down, he was a guest occasionally on certain investment shows. I can't remember if it was Mad Money or what it was. And to my knowledge, he has not been back since. So that may have actually hit him worse than the jail time he served.
Wow. Sounds like quite a character. And speaking of characters, let's talk about Dance Moms and ABI-Live Miller. Who is she, Aaron?
ABI-Live Miller was the star of a Lifetime television show called Dance Moms. And the premise of this show is that ABI-Live is a dance coach with her own studio, and she would coach a team of girls, and then the moms would be those girls' mothers, who would usually have a lot to say about both the other their daughters and the other team members, and ABI-Live Miller herself. ABI-Live was perhaps, she didn't always use positive reinforcement in coaching those girls, but she was very competitive and would train them for dance competitions.
And so what did she do?
So ABI-Live Miller, she had actually, before the show began, she had filed an individual Chapter 11 petition in the Western District of Pennsylvania, and her dance business was a sole proprietorship. When she had, shortly after she filed, this would have been, I think 2010, but in early 2011, she got picked up for a pilot for a new show, the Dance Mom show, and it turns out that the pilot was a success, and she contracted with, I think it was through A&E Television, which owns Lifetime, but she contracted for appearances on episodes, and initially I think she was getting, $10,000 an episode, and then it went up to $25,000 an episode as a talent fee. But so she was making money hand over fist, but the problem was is she wasn't very upfront about these monies with her in the Chapter 11 case. And so she had filed a disclosure statement and a couple of disclosure statements, but wasn't really fulsome about her income on those. And she also didn't disclose some of her income on her operating reports, which are signed under penalty of perjury. And so what happened was that one night, the bankruptcy judge in the case was channel surfing and came across the show. So he saw that Dance Moms was actually a thing, and a little bit confused that she wasn't reporting more income on her operating reports and her disclosure statement and plan. And there were a number of hearings where the judge directed ABI-Live to amend her operating reports. I think she ended up was able to confirm a Chapter 11 plan where she had to pay her unsecured creditors in full up front. But eventually she was charged with committing some bankruptcy crimes. And so, among other things, there was an investigation that showed that among other things, she had been traveling overseas to the UK and Australia and making large sums of cash from master class appearances. And she had actually coordinated with some of her friends to bring over up to $120,000 in cash into the U.S. in Ziploc bags. And so, in fact, she had actually sent texts to her friend saying, or to an associate saying, I have all this cash. I need a little money laundering. So she was charged under several statutes, including 152, concealment of assets, and also statutes regarding dividing up of cash receipts. She ultimately pled guilty to a count of concealing bankruptcy assets and a count of not reporting an international monetary transaction. So she did quite a bit.
Okay. Well, let's go to the next slide, and let's talk about, here we have another picture of Matthias's cat. Let's talk about how some of these crimes are sometimes uncovered, and then we'll talk in the last section about how attorneys can avoid being caught up in these kinds of messes. And let's go to the next slide and look at some of the ways in which bankruptcy fraud is often uncovered. And
I'll just point out, Eric, that real quick, that is not Mr. Whiskers. Mr. Whiskers is a calico, as we saw early on. And this cat is plainly a straight black cat. But at any rate, sure. So how can you get busted? Well, there's actually a lot of ways. The U.S. trustee, in other words, Aaron's boss, for example, may decide to investigate things, and that can easily get you in trouble. Bankruptcy, as many of us know, has two things. First of all, broad investigative powers. The trustee is generally charged with investigating the affairs of the debtor under the bankruptcy code. And there's also a mechanism, and there's, of course, the 341 meeting of creditors. And as uninteresting as those things can frequently be, that at times can be very interesting because the debtor is testifying under oath, and creditors can pretty much ask whatever they want related to the case. So, but maybe my favorite device is the Rule 2004 exam. Most people on this webinar probably know what that is, but to the extent you do not, Federal Rule of Bankruptcy Procedure 2004 basically allows a party to investigate anything, depending on which district you're in. You may need to actually file a formal motion, or it may be the kind of thing where you can set it for hearing, and unless somebody objects, some local districts have that in the local rules, it's basically set. But essentially, you can investigate anything that's related to the debtor's financial condition, business, etc. Rule 2004 exams have been described in the past as a fishing expedition. The scope, pretty much everyone agrees, is generally broader than a deposition would be. And in fact, there is even case law saying that if you have a pending adversary proceeding or lawsuit, you cannot use this device because it exceeds the deposition scope, and you have to actually go with the deposition in that instance. And the other thing you can do there, aside from investigating and getting the witness to testify under oath, is that you can actually request document production just like you would under the Federal Rules of Civil Procedure, for example, with requests for production of documents. So you can get a lot of records. You can get a witness to testify under oath as long as it relates to the scope of the debtor, the debtor's financial condition, the debtor's business dealings, etc. And there's a lot that can come out there. So, so that's one way that it frequently can happen. Another one is that generally the trustee is going to succeed to the debtor's privileges. There's an opinion, I hope I'm not mistaken, that I believe it's the Commodity Futures Trading versus Weintraub opinion out of the 80s, where the Supreme Court ruled that the trustee succeeded to the debtor's privileges. So what does that mean? Well, a lot of stuff that the debtor might be able to keep hidden before under the guise of privilege, the trustee would therefore have access to. And, you know, there's maybe a difference here between the theoretical scope of the law and the reality, which is that obviously to the extent that you are attempting to perpetuate a fraud with a privileged communication, that communication is not privileged. However, the reality is it's always easier to say it is privileged, I suppose, if you're a malfeasor, and then force someone to show that it was used, that it's not privileged because you were trying to perpetuate a fraud with it. So that's another way you can get caught. Poorly drafting a fraudulent document. The reason there's a question mark after this bullet point is this is actually something that I witnessed at one point, or I witnessed the hearing that resulted from it. What had happened was I was a law clerk for a bankruptcy judge out of law school, and a debtor had, and I don't remember exactly how this was being used in the case, but the gist of it was he had a trust agreement. And the trust agreement, unfortunately for him, it had supposedly been dated several years prior. And I think the creditor's attorney had noticed that it referenced a law that was not, in fact, enacted until several years after it had supposedly been, I guess, settled would be the proper term for a trust. In other words, it was extremely suspicious, and it was very obvious that the thing had actually been created much later to perpetuate a fraud. So that's one way your client can get caught, is he poorly drafts a fraudulent document and references a statute that is not in existence as of the time the document was actually created. Another one, fraudulently putting someone into bankruptcy without his knowledge. Another one that sort of arose out of personal experience. When I was a clerk, there was a company, and it was one of these pay your bills or stop your foreclosure companies is what it really was. And it wasn't just in Texas. I think they were operating out of another state, maybe California. But what had happened was one way they would stop foreclosure was they would put people in bankruptcy without their knowledge. And these are people who had reached out to the company and they had gotten their information, but they certainly had not consented to be put in bankruptcy. And at one point, the judge I clerked for had the gentleman running the company on the stand, and he actually was an attorney involved in it. And he asked me, he said, well, what I don't understand here is that, you know, if you didn't have permission from these people to file bankruptcy, you filled out schedules, you filled out a statement of financial affairs. How did you do that? And he said, well, I estimated. So ultimately, he was referred to the United States attorney. I believe the company had also put people in bankruptcy in front of other judges in the district. And while I don't know ultimately how that came out, I doubt it came out very well for them. So these are all ways you can get caught. Aaron, I'm sure you've seen some others in your line of work that probably are not on here.
No, absolutely. And I just wanted to point out, too, that it's with the U.S. trustee or the panel trustees or the 13 trustees, it's not so much that we're out there looking for, we're investigating crimes, but these issues come up in the context of civil proceedings or civil investigations. And so a lot of times, if there is a creditor filing a complaint for a determination of dischargeability under 523, there may be crime issues implicated just by the nature of the complaint. Another is Section 727, which is denial of discharge. And oftentimes, the same acts that might lead to a denial of discharge may have criminal implications. Or if a party seeks appointment of a Chapter 11 trustee under 1104, that might be implicated in that there might be factors raised there that might lead to a subsequent indictment. It just depends. I would note, too, a lot of times creditors have information. They may have been chasing a party over a long period of time, and that party uses bankruptcy for fraudulent purposes. And so there's a number of ways that these issues come to light.
Okay.
And
So,
also,
go ahead, Aaron. Sorry.
I was also going to note as well that Matthias had talked about the issue of privilege, and there is some conflicting case law as to whether a trustee controls the privilege for an individual debtor. Certainly a trustee would control privilege for a corporate debtor, a business entity, but it's a little bit divided the case law is a little bit divided as to whether the trustee holds privilege for an individual debtor. But we've seen this come up this has become an important issue, for example, in cases where a Chapter 11 corporation might be under investigation by law enforcement, and if a trustee is put into place, then the trustee certainly stands in the shoes of the debtor and can waive the privilege, and we've seen that happen in cases within the Northern District of Texas, certainly.
Okay. So we've talked about some of the ways in which bankruptcy fraud can come to light. I guess the next question is, what should an attorney do? What maybe must an attorney do if he or she discovers potential bankruptcy fraud? Either one of you can jump in on that one.
Aaron, you go first, and then I'll jump in with a couple thoughts after.
Sure. I think it depends on, I think certainly an attorney, under the ethics rules, if you know that a crime is being commissioned, I think you may have a duty to report that. There's also the issue too, if an attorney is representing a business entity in bankruptcy, certainly advising the debtor's representative to get their own criminal counsel. I would certainly say that would be a suggestion there.
What about does the U.S. Trustee's Office have any kind of obligation, maybe a statutory obligation, to make referrals?
Yes, we certainly do have an obligation to make referrals. If there's a suspected bankruptcy crime, yes. We're obligated to make those referrals to the U.S. attorneys.
How does the referral process work? Can you sort of walk us through how it's initiated and then how it plays out?
Well, our office, under statute, we're required, if we suspect a bankruptcy crime, we will make a referral to the U.S. attorneys, and then we make the referral. The U.S. attorneys ultimately decide how to handle that referral. And so if they decide that this is something that they want to investigate, they can certainly ask us for help in terms of understanding bankruptcy or documents, but it's something that the U.S. attorneys ultimately prosecute, not our office. We're civil. And
what is the threshold for deciding to make the referral? I mean, what level of information would warrant the referral?
It would be if we believe a bankruptcy crime has been committed. And so it's not up to us to decide, well, is there enough money involved or what the property is? If there's reason to suspect that a crime has been committed, we have an affirmative duty to refer it under statute. And so it's not up to us to sort out whether a crime truly has been committed or not. It's whether we think something's been committed or potentially committed. And then ultimately the U.S. attorneys, relying on their own investigators, and that might be the FBI, might be the criminal division of the IRS, it might be U.S. postal inspectors, there's other federal investigators out there, then they ultimately determine whether to proceed with an investigation and prosecution.
Okay. Matthias, let's talk about private attorneys in private practice. What are your thoughts on what they should do if they encounter potential bankruptcy fraud?
Sure. So this is the scenario where, not the scenario of what you can do to prevent that, which we can discuss, but it is has now come to your attention that your client may have committed bankruptcy fraud. So the first thing I would do is I would consult with an ethics expert, and I would consult with a criminal attorney if I believe there's any chance of criminal liability here. And I understand that we're always sensitive to cost. We don't want to throw money away, but the reality is, the problems here that can result both reputationally and in terms of if you ultimately get charged are very serious. And, hopefully it's the kind of thing where you don't ultimately have to pay these people a lot of money. But the concerns I would have, first, the criminal attorney is kind of a no-brainer. We obviously understand that we want to know if your criminal attorney can tell you potentially what your liability might be and what steps you can do to reduce it. The reason I'd have concerns about talking with some kind of an ethics expert, whether if it's even like, let's say you're at a large firm and maybe you have, usually most firms have, some kind of a either handles this or a chair or something like that, right? But I want to know, number one, what can I reveal? What am I obligated to reveal, and what can I not reveal? Because under the ethics rules, there are certain times that you're obligated to make disclosure, and there are certain other times where you can't participate in furthering something, but you're not necessarily able to disclose as much as you think. And I would want, essentially a professional opinion on that. And the third thing I would consider is this something where it makes sense for me, and it probably does, to withdraw? And if I withdraw, what steps do I have to take both to preserve, to comply with the ethics rules? Because just as a practical matter, I'm not a criminal attorney, and I'm certainly not a prosecutor. But if I'm looking at this and I see a guy who Lenny was not aware of something, but then continued representing someone he may have suspected was a fraudster for months, that looks a lot worse than someone who finds out about something, discloses what he can disclose. If you say he can't, okay, but at least withdraws from representation. That's something to seriously consider at that point, both because you don't want to further something that's going on that may be a fraud, and because, frankly, it looks good for you. So those are the three things I would consider are some kind of an ethics opinion, potentially at least retaining a criminal attorney so you have someone to go to if something happens, and then, what steps do I need to take potentially to withdraw in this case, et cetera.
Okay, so that's sort of from the perspective of an attorney who believes his or her client may have engaged in bankruptcy fraud. What if you're representing a creditor in the case and you believe that other parties in the case are engaged in bankruptcy fraud? What should you do? Do you take it to the U.S. Trustee's office? What's the appropriate action there?
Yeah, so I think that kind of depends on what you know, and probably the best thing to do is bankruptcy gives you a lot of investigative materials because there's a lot of stuff filed under oath. You essentially file financials under oath. That's effectively what schedules are. You have to file under oath what transfers you made during certain periods pre-bankruptcy, right? And you've got the 2004 exam I discussed. You have the meeting of creditors. The 2004 exam in particular is a great weapon. So maybe you try to investigate as much as possible. If it comes to your attention that fraud is taking place, there's a couple things you can do. Well, one of them is you may try to get a bankruptcy trustee appointed, which fraud is one basis under let's say Chapter 11. I'm sorry, we mostly use Chapter 11, so I'm looking at this from the perspective of getting a Chapter 11 trustee. In Chapter 11, you may try to get a Chapter 11 trustee appointed, and that's the kind of thing where actually require the fraud to be disclosed. The other thing, and of course, reporting is always an option. The one thing that we always have to be careful of under the professional rules is that, the ethics rules generally prohibit attorneys from threatening criminal action for the sole purpose of obtaining a settlement. And that's frequently something where, many of us have had clients who believe criminal action is occurring and have wanted us to make that threat, and you always got to be careful there. So I think that is something to be aware of. So anyway, I guess what I'm saying is, investigate, report if necessary, and always be careful, though, to the extent that you're trying to negotiate something that you're not violating the ethics rules by somehow making some kind of an improper threat to obtain a settlement.
I would note, too, just jumping in here, that the other a creditor also can provide information to the U.S. Trustee's office. Although I would also note that when we make referrals to the U.S. attorneys, we can't comment on those to the public. And so, if somebody asks if I've made a referral on someone, I can't talk about that. I can't disclose whether I've made one or not. Another option, too, for creditors is that you can, if you have information, you can always go to law enforcement yourself, whether going to the U.S. attorneys yourself or making a referral to state or to federal or state law enforcement agencies.
Okay. All right. So before we go to the next slide, I want to note that I came across a report from the Department of Justice showing that they estimate that 1 in every 10 bankruptcy cases has an element of fraud associated with it. That same report also indicated that the U.S. trustee program had made over 2,100 bankruptcy and bankruptcy-related criminal referrals in 2016. So this goes to show you that bankruptcy fraud is out there and can be very prevalent. So let's go to the next slide and talk about ways that attorneys can avoid being caught up in it. And either one of you can kick this off.
Sure. So a lot of this, since a lot of this is like private practice stuff, I guess I'll lead. So essentially, one thing, this is what I, especially if I was a consumer attorney, which I'm not, but just because the volume of clients is frequently higher, I would seriously consider having a client sign a handout explaining, relevant provisions in plain English of the bankruptcy crime statutes, explaining what has to be done, and frankly saying, look, I understand that here's what I have to do. I sign my schedules under oath. I have to properly dispose my assets, and I may be subject to criminal liability if I violate this. And the reason I would have a client sign that and initial that up front is, that is, if nothing else, you can't prevent someone from committing fraud by doing that necessarily. Maybe you can. Frankly, a lot of times you probably could. But, someone may do it anyway. But at least at that point, from an attorney perspective, I've covered my rear. Aside from that, I think that it's important to, investigate the documents, to read them, make sure you understand them, see if it makes sense. There's always going to be things that the client has knowledge of that you cannot 100% verify, and you just have to do your best. But, for example, you don't want only your paralegal to prepare the schedules and you not even look at them, because that's the kind of thing that, if your client commits fraud and that comes out, that doesn't look good. Even if it's not necessarily criminal, it's going to look bad from a malpractice perspective. When in doubt, to the extent possible, disclose, because it's actually pretty hard to get in trouble for over-disclosure for the most part, right? As long as you do it up front and it's not something that comes out later, it's pretty hard to get in trouble, and it's usually something you can address. I can't see how many judges have said, what I like about this attorney, I'm not talking about myself here, just a particular attorney they may like, is he comes into court and he says, here's the problem with my case, and here's why it's not really a problem. So, again, it's better to address it, publicly if you have any kind of doubt on it, and if you can, without violating privilege issues or anything like that, then to hide it. One thing to just kind of watch out for is social media. We don't have a huge discussion of it in the PowerPoint, but some of you may remember there was the Curtis Jackson, the 50 Cent bankruptcy case, where he had posted some pictures a while back on social media with what appeared to be money spelling out the word broke. And that initially triggered a huge investigation into, is this guy hiding assets? And in that particular case, it turned out it wasn't. It was play money that, that was off one of his television shows, et cetera. So, not something that worked out poorly. It actually worked out pretty well to promote one of his companies, actually. But that usually isn't how social media, comes out. Any kind of investigator or attorney who does a lot of investigations is always going to pull someone he may suspect being a bad person, pull whatever social media you can to see what, is being discussed on there. So that's just something for your clients to be aware of. but for me, I think the biggest thing is to get as much possible in writing, spell out the client's obligations in writing, have the client sign them so there's evidence that the client, that this was communicated to the client, and, when in doubt, disclose. And I think if you do all of that, the odds of you actually being charged criminally are pretty low. That doesn't necessarily mean that someone may not accuse you of malpractice if something goes grossly wrong, and even if it isn't malpractice, that's a lot easier to do, but it will at least generally protect you, I think, most of the time from any kind of criminal conduct your client may engage in. Aaron, go ahead and jump in with whatever I'm missing.
No, I would absolutely agree, and I think that the tendency of so many folks, especially debtors, who are charged with a bankruptcy crime or even a fraud allegation is to say, oh, but my attorney didn't tell that to me, or, oh, they told me it was okay. And again, I think having the handouts where the client signs indicating that they understand that they have to be truthful, sometimes having a witness in the room as you explain these things to a client is helpful so that it's not just a he said, she said type of situation. And I think sometimes, too, just when talking with your client and helping them fill out their schedules and statement of financial affairs, just looking for certain red flags, looking at maybe the types of creditors, if there's judgment creditors, finding out why those judgments were obtained, if there were any fraud allegations in state court. Sometimes even just a simple Google search of your client's name may turn up some things that may prompt you then just to drill down further when you're talking with your client about their bankruptcy schedules. So those would also be some suggestions.
It seems that the Rule 341 meeting is also a almost sort of backup approach, an insurance policy for you if you're debtor's counsel, because one of the questions is always going to be whether the client has failed to list any assets, right?
Absolutely. But I would note that it's probably better to meet with your client at some point before the actual 341 meeting. Sometimes we've seen, especially with some firms that handle primarily consumer cases, where the attorney appearing at the 341 meeting on behalf of the client may not have been the party who actually met with the debtor and went over their schedules and statement of financial affairs beforehand. But yes, the 341 meeting is another opportunity to go over those requirements.
So the message there is avoid surprises at the 341 meeting.
Exactly, yes. And it's not a good thing when the counsel for a debtor is surprised at the 341 meeting by questions that are being asked by a creditor or other parties.
Right. Yeah, and I think also, as Eric is pointing out, that, if your client does get in trouble for that, that's additional backup for the attorney, provided you didn't know about the hiding of the assets, where you can say, look, if the guy testified under oath, I didn't know. I sat there and I listened to that. He's the one that said it, and et cetera. Now, that doesn't preclude someone from contending otherwise or making malpractice allegations against you, saying you didn't explain properly and they didn't understand. But it is backup if there's criminal liability involved.
Okay. Well, I think that's about it for our presentation. We can open it up for any questions that people have. And if we don't have questions, then we'll turn it back over to Amy at ABI.
Great. Thank you so much. Thanks, Eric, Matthias, and Aaron, for sharing your expertise and insights on this topic. It was a very interesting webinar, and we appreciate you being with us today. And thanks also to the ABI Commercial Fraud Committee for hosting the webinar. If you're not a member of the committee but are interested in joining, membership is free to you as an ABI member, and you can sign up for this or any other committee at committees.abi.org. Of course, if you're not an ABI member and interested in joining, you can find more information and sign up at abi.org. For those of you needing CLE credit for this program, our CLE coordinator will send an email to you in 2 or 3 weeks with directions on how to obtain your CLE credit. Thank you again for attending our ABI-Live webinar, and we look forward to having you again. Our next webinar can be found on our website at abi.org. Thanks.